My name is Andre Jordan. I thank you for reviewing my situation. I'm reaching out because I am in serious need of legal help. Multiple agencies are desperately trying to silence me, and for good reason. This case is well documented and provides detailed accounts of failing to protect tenants, leading to one explosive 3-week period for me. My situation provides insight into the outcome of administrative paralysis and the efforts agencies will go to bury unethical practices, including threatening me and avoiding sheriff's delivery. The following video will provide a brief overview. For more information, please contact me direct at 747-277-9188 or email me.
The plaintiff in this matter is Andre Doc Jordan. The targets of the litigation are Conam Management and Amani Apartments. The core grievance driving of suit is a documented systemic failure by property management to address severe safety threats directed at the tenant. Specifically, management was notified of 2 distinct hazards: a violently aggressive guard dog permitted in common areas and a physically assaultive neighboring tenant. Rather than intervene to protect the reporting tenant, the landlord issued formal disciplinary action against Jordan for reporting the attacks. The strategy centers on a specific set of physical evidence, management-controlled security footage of the physical altercations that explicitly contradicts the landlord's official legal narrative. Based on the documented timeline and statutory multipliers, the total liability exposure for the defense is estimated between $225,000 and $300,000. The legal strategy utilizes the management's own withheld evidence to construct a risk profile that makes a traditional defense unsustainable. This profile is designed to bypass prolonged discovery and trial proceedings by forcing the landlord's insurance carrier to assess the cost of an immediate settlement. The result is a case where documented liability and suppressed evidence intersect to create the conditions for a significant 6-figure settlement. The chronology of negligence begins in early January 2026. Jordan filed repeated formal complaints detailing an unrestrained German Shepherd lunging at him in the building's common spaces. The hazard was not isolated to residents. Records show a specific incident shortly after, where the same unrestrained dog dragged its handler and threatened building staff in the lobby. This establishes the factual baseline for the first major cause of action: negligent retention of a dangerous tenant. To prove negligent retention, we must confirm management had explicit authority. This lease document outlines binding rules of conduct. The provision grants the right to demand permanent removal of nuisance animals. The annotated text confirms management had the legal ability to enforce this anytime. Evidence shows this apathy is part of a broader pattern. This tenant review details a separate instance where corporate management failed to return contact for months regarding physical safety concerns. Corroboration from other Conam properties reveals a documented history of unpredictable management behavior and arbitrary threats directed at residents. By ignoring their own lease terms and the established bite history, management has provided the factual basis for a negligent retention claim, estimated by legal analysis to be worth up to $75,000. The threat escalated on January 25th, when Jordan intervened to help a domestic violence victim escape from Unit 316. While securing the victim's belongings, Jordan was physically and verbally assaulted by the domestic violence perpetrator. Jordan remained non-offensive throughout the encounter. A neighboring tenant from Unit 315 then opened their door and joined the verbal and physical assault against Jordan. To amplify the threat, the tenant in 315 intentionally deployed the German Shepherd, letting the dog barrel down the hallway toward Jordan without restraints. The harassment continued into the following morning. This photograph shows the direct physical manifestation of that harassment: a pile of laundry, trash, and empty condoms deliberately dumped outside Jordan's unit door. Jordan immediately filed official LAPD reports, firmly documenting the timeline of the assault and the underlying domestic violence issues. He concurrently filed reports with Animal Control to log the dog attack and its prior history. These events trigger 2 specific legal claims: breach of implied warranty of habitability and violations of the Fair Housing Act. Management's failure to intervene in known, escalating third-party violence legally rendered the premises unsafe and uninhabitable for the targeted tenant. Management issued their official response to the assaults on January 30th. They issued a formal lease violation directly to Jordan, accusing him of instigating the event. The actual aggressors received no such violations. The property manager verbally admitted to Jordan that building security footage showed him assisting the victim and cleared him of any wrongdoing, yet they processed the violation anyway. This bad faith action directly triggers the LA Tenant Anti-Harassment Ordinance, known as TAHO. Knowing the video proved Jordan's innocence, COAM actively evaded a court-ordered subpoena duces tecum, designed to compel the release of the footage. Sheriff's deputies logged multiple unsuccessful delivery attempts because the leasing office intentionally dodged service to keep the evidence suppressed. This active suppression of evidence, combined with retaliatory ticketing, upgrades the standard habitability claims to warrant punitive damages. This diagram outlines Tahoe's specific financial penalty structures, which issue fines of $2,000 to $10,000 per individual violation. More importantly, because retaliation is verifiable, Tahoe allows for treble, or 3 times, compensatory damages to the victim. By attempting to falsely frame a one-sided assault as a mutual dispute, management activated the most expensive punitive tiers of local tenant protection laws. This chart synthesizes the total financial exposure for the landlord, beginning with the baseline claims. We factor in $2,000 to $5,000 for the habitability breaches and stack the $50,000 to $75,000 for negligent retention. Next, we add an estimated $50,000 to $75,000 in punitive damages for gross negligence and evidence suppression. Finally, the Tahoe multipliers generate the largest single portion of the claim, adding between $150,000 and $180,000. This creates a conservative exposure floor of $150,000. Depending on the severity of the per-violation fines applied, the aggressive maximum penalty scales past $350,000. Analyzing the facts, the most realistic settlement target zone falls between $225,000 and $300,000. After factoring in a standard 30% attorney contingency fee, the net recovery value to the plaintiff is estimated between $165,000 and $200,000. The pivotal factor in this calculation remains the security footage. To defend their actions at trial, management would be forced to introduce the very evidence they suppressed, proving their own gross negligence on the record. This evidence profile allows counsel to bypass the uncertainty of a trial, pushing for an insurance settlement by forcing the defense to confront their own most damaging evidence.